And so mediation is clear that the court desires this to be pursued. It's not been ordered by the court, but I believe it's a positive direction and it's a positive step, and it's a good faith step by the board to show that they are really serious about trying to resolve issues. Where mediation ends up is anybody's guess. I mean, it could end up 100 different ways, but it gets everybody talking, and it has a professional in between helping to, have the conversations move ahead. Sorry about that. And that's a positive step. So I think it's just good. I mean, it might end up with no result, but in my experience, 40 years, lots of cases get resolved by mediation that you never thought would ever resolve. So I take it as a very positive step, and again, a very good faith step by the board.
What goes through your mind knowing that the court is still proceeding with that $4 million settlement case?
Well, the court has to hear the case. I mean, it's not like it's the judge's decision. I mean, I fully expect the judge will deny the motion. I mean, you've all seen our responses and everything. So I fully expect we'll win that motion. Again, this is evidence of it here today. I mean, we wouldn't be pursuing mediation if we thought there was going to be some $4 million settlement enforced. We just don't think that's going to be the end result, but obviously it's up to the judge.
As much as I love being here every day.
That's right.
How long do you think this process might take out?
The mediation process?
Yeah.
Well, we have to agree on a mediator, and honestly at this point I'd have to hear from Attorney Howard whether Ms. Hambley will agree to mediation. Assuming that they do, then we have to agree on a mediator. Usually the attorneys share lists, and then you see if there's any common names in the list. And if we can't agree, ultimately the judge could decide. But I can't remember the last time I had to go back to a judge to agree on a mediator. I mean, usually the attorneys can work that out. Then once we've picked a mediator, then we contact that mediator, what's your schedule, and we get in as soon as we can. I mean, realistically, you're probably talking January sometime at the earliest to have mediation.
This subcommittee, obviously Moss explained, they don't have any powers.
Of course not. They can't by law. Right.
Explain the subcommittee to us.
Yeah, by law, it's pretty hard to go to mediation with 11 people. Well, right now 10, but assuming the board appoints a new commissioner, there would be 11 people. That's kind of unwieldy. So the case law is clear in this area that special committees can be appointed, subcommittees that they cannot have any authority, they cannot have any power. And so that's why Commissioner Moss was very clear in the motions that this subcommittee cannot agree to anything. All they can do is make a recommendation, and then it comes back to the full board for a vote. But with 5 people on the subcommittee, the special committee, then we would hope that then the entire board would go along with whatever recommendation that is made. And I think it sends a message, and it's very important that this is a bipartisan committee. By having Doug Zylstra on the committee, to have his voice heard, and others, I think that's important. And again, I think that demonstrates the good faith of the board.
Can you talk about why the board hasn't had a vote on whether to fire Ms. Hambley after 2 days of hearings? What's the reason for not doing that?
Well, because of what we're doing here right now, because there have been settlement discussions, and because there's going to be mediation. There's no point to come to a final decision that some people might like, some people might not like, and then you're still embroiled in more litigation, whichever way you go, and things like that, if we can resolve it. And so it's just common sense that you try to resolve things if at all possible. So that's all that means.
Do you feel like you're closer than you were a couple weeks ago, or you've moved closer over the last month?
No. No. But that's part of the mediation process, is to help make that happen.
Who pays for mediation, or is there a cost to it?
Well, sure, there's a cost in the sense of paying a mediator, but it's in the big scheme of things, it's a very small cost. As opposed to going to trial and all of the litigation that you've all seen going on right now, it's way less costly to do it this way, and especially if it achieves the result, which everybody wants, is a reasonable resolution that all sides can live with. That's the point of mediation, is to try to get to that point.
To follow up on his question, so the county, or is it the attorneys that would have to pay for a mediator?
Well, the county pays the mediator, of course, yeah.
Do you think a possible outcome of this mediation is that Ms. Hambley could stay, or do you feel like
Of
that's
course.
unlikely?
No, I think anything's on the table. Like I say, it could go 100 different ways. That's all I can say, you know, until we get into the mediation and see what people are saying and, you know, go from there.
Can I ask, why didn't you guys do this a couple weeks ago? Why now?
Well, we did offer a couple weeks ago to do mediation, and Ms. Hambley flatly refused. So now, to her credit, I mean, Ms. Howard did contact us a day or two later. When we were here a couple weeks ago, we offered mediation. Sorry, I keep doing that to you. We offered mediation. They said no. She called me a couple of days later and said, well, we've reconsidered. We would look at mediation. So then we were talking about, of course, we've not had any further meetings since then. And because yesterday in court, and comments the judge made, we just felt it was appropriate, like, okay, let's bite the bullet, let's do this. I mean, we offered it a couple weeks ago, let's do it. And we don't need to wait around. We don't have to wait for the judge to order it. We can just do it. And so now I guess the ball's in their court if they're going to agree.
Would the closed session not minutes, but like discussions that happen during closed session, would that be brought up to the mediators so they can better understand what's going on?
No, again, anything that happens in closed session you can't talk about, you know, and you can't divulge minutes and that sort of thing, which is, of course, the crux of the problem with the settlement issue that's pending before the court. But that doesn't matter because everybody can talk and have their voices heard at the mediation, and you can talk about whatever. It could be a lot of the same information. It might be totally different information, but mediation is its own animal, its own process. So,
How many times have you been through a mediator?
oh man, I've been a mediator myself. By this point, I've probably done a couple hundred mediations over the years. Mediation is very common in the courts. Most people don't realize that. It's a very common process. Judges love it. The attorneys love it, you know, because it does help resolve cases. And so, which is part of why I think it was an appropriate move by the board today to take this good faith step and put it out there and say, okay, we're prepared to do this and move forward. Now it's up to Ms. Howard and Ms. Hambley as to whether or not they want to participate or not.